Okay, well, good morning, everyone. We might make a start. Welcome to our webinar on the 2025 Employment Law Wrap-Up. My name is Simon Obee. I'm Head of HR Advisory here at Employment Hero, and I'm here with my colleague Neath, who is the HR Advisory Manager, who you'll meet in just a second. If you don't know what Employment Hero, if you don't know what HR advisory at Employment Hero is all about, it is our advice service. Our customers get access to unlimited HR and employment law advice by a team of HR experts such as Neath and myself. You also get access to unlimited template documents, a compliance audit when you come on board, and representation in the event of claims by employees. So that's HR advisory. But what we're here for today is to deliver this webinar. So just a few housekeeping things. The advice we're going to provide is general in nature, and so please seek professional advice on your own individual circumstances. We will send out a copy of the slides and a copy of the recording. If you have any questions, please use the Q&A function, and we'll try and leave some time at the end to answer them. Our colleague Georgia and Tim from the HR advisory team are also online, and they'll answer any quick questions they can through the Q&A function. But if we don't get to your question, we do get literally hundreds of questions. We'll put together an FAQ document afterwards and try and get through as many as we can. I think that's it by way of housekeeping. So there's a pretty packed agenda today. I won't go through all of it, but in a nutshell, we'll talk about key legislative updates that occurred in 2025, and both at a federal and state level. We'll then look at some important case law in 2025, and then we'll look at changes that are going to occur in 2026 and beyond. So I will hand over to Neath to get things started.
Amazing. Thank you so much, Simon, and hi, everyone. We've got a lot of content to cover today, so we'll just dive straight in. Next slide, please, Simon. So we're kicking off this session with a huge employment law change that came into effect on the 1st of January this year. And the change that I'm talking about, which is not going to be a surprise to any of you, is the introduction of wage theft laws. Section 327A of the Fair Work Act makes it a criminal offense to intentionally underpay employees. And as mentioned before, this provision came into effect at the very, very beginning of this year, clearly sending a very strong signal to employers that intentional underpayment will not be tolerated and will result in very severe consequences. So, what are those consequences? There are two types of applicable penalties here. For individuals, they could be subject to the following court orders if they are found guilty. So the first one is prison time of up to 10 years, and the second one is a penalty of up to $1.65 million. Companies, on the other hand, could face a penalty of up to $8.25 million. So as you can see here, these penalties are really onerous, especially for small to medium-sized business owners. And as such, I cannot emphasize enough the need to ensure that if you identify any underpayment, it needs to be rectified as soon as possible, because failure to do so could paint a picture that the underpayment is intentional, which then increases your exposure to wage theft liability. I can appreciate that this might sound a little bit scary to many of us, but I want to draw your attention to the fact that there are a number of exceptions to this law, which essentially give employers the opportunity to effectively come clean if they face the prospects of being charged with this offense. So the first exception here on our slides is through the use of cooperation agreements. An employer who faces the prospects of being charged with wage theft can voluntarily self-report to the Fair Work Ombudsman and request a cooperation agreement. If the Ombudsman agrees to enter into such an agreement, then they cannot refer you to the Australian Federal Police or the Director of Public Prosecutions for criminal prosecution for as long as the cooperation agreement is in force. There's a caveat to this, though, that I want to make clear. Although the ombudsman cannot refer you for criminal prosecution while the agreement is in effect, it doesn't mean that they can't take enforcement action against you through some other way. They can still take civil enforcement action against you. The second exception is if the employer can show that they've complied with the voluntary small business wage compliance code. This exception is only available to businesses that have a staff headcount of fewer than 15 employees. And the code is framed in a way that is quite similar to a checklist. It lists out factors that the ombudsman looks at when they decide whether you've complied with the code. We've listed some of those factors here on the screen for you to have a look. You don't have to check off every single factor in the code to get the protections of the code. And no one single factor is critical or determinative. What the ombudsman does is they'll look at the overall picture and the employer's particular circumstances to decide whether the code has been complied with. If it has, the ombudsman would not be able to refer you to the AFP or the DPP for criminal prosecution. But again, as I said before, they can still take civil enforcement action against you. There are also a number of other technical exceptions as well that could potentially apply, but these two are the main exceptions that are available to employers. Next slide, please, Simon. So that's that about how the new wage theft law works. It doesn't necessarily have to be something that scares you. Essentially, what it requires from you as employers in practical terms is actually quite simple. First, it requires you to be proactive when it comes to paying staff correctly. So the questions that you would pose are something like, have you done your pay audits? Are you doing them regularly enough? Are you on top of your record-keeping obligations? When you identify an underpayment, are you acting fast enough to actually correct it? And if the answer is yes to all of the above, then you're likely to be compliant. Okay, now let's switch gears a little bit and talk about something that is a little bit less intense. And the next part of this part of the webinar is going to be about casual conversion. So next slide, please, Simon. Okay. So the new casual conversion rules have been in place for large employers for quite some time, actually. But the 12-month grace period for small businesses, so what I mean by that is those with fewer than 15 employees, has now ended. So as of the 26th of August 2025, small businesses are now fully subject to the new casual conversion framework. So what has changed? The new framework establishes what is called the employee choice pathway. With this pathway, an eligible casual employee who's been with your business for at least 12 months can now formally notify you in writing that they want to convert into a permanent part-time or full-time employee if they believe that they no longer meet the definition of casual employment or the definition of a casual employee, essentially. When you receive a conversion notice from your casual employee, you have a choice to make. You either accept the notification or you refuse the notification. If you wish to refuse the notification, you can only do so if they still meet the definition of casual employment. And by that, I mean the employee still works irregular hours, they still work sporadic hours, or they can still decline shifts, right? And if they no longer meet that definition, then you would only be able to reject based on reasonable operational grounds, such as the position not existing in the foreseeable future, or that converting into a permanent sort of role would fundamentally change your business operations. Next slide, please, Simon. So the Act prescribes quite a specific way on how to deal with a conversion notification. We've set this out here on the screen for your own reading, but the key requirements that I'd like you to bear in mind, there are two of them. So the first one is you have 21 days to respond to the conversion notification. And also, before you respond, you must also consult with your employee as well. Now, to conclude, it's also worthwhile for me to note that the Fair Work Commission can now deal with disputes in this area. If a dispute ever arises with respect to casual conversion, you'd want to make sure that you're in the best position possible to deal with it. And one of the best ways to strengthen your position is to ensure that you have a clear, documented process for receiving, assessing, and responding to these requests. Now, moving on to another major legislative development that is now active for small business employers as well, as of the same date, so the 26th of August 2025, is the right to disconnect. So next slide, please, Simon. Thank you. So this is a new entitlement that gives employees the right to refuse to monitor, read, or respond to contact from their employer or a third party on their employer's behalf outside of their working hours. The only exception to this is if the contact is not unreasonable. So just to be clear, this is not a ban on out of hours contact. It's more about an employee's ability or right to refuse unreasonable contact from their employer. So, what's considered reasonable or unreasonable? There are a range of factors that are looked at when deciding whether contact is reasonable or not, such as the reason for the contact itself, the level of disruption it causes to the employee's role, level of compensation, and the nature of their duties as well. Let me give you two examples to practically illustrate what reasonable looks like and what unreasonable potentially looks like. So, with the first example, imagine you run a web-based retail business, and at 2 a.m., your e-commerce site crashes, which then stops all sales. A manager calls the IT systems administrator, who is responsible for server maintenance and emergency fixes, to alert them to this critical system failure. This contact is likely to be considered reasonable for obvious reasons, really. So the first reason is the call is genuinely urgent, right? It directly impacts the company's core function, and it also relates to an immediate and unforeseen emergency. So let's contrast that with our second example. So we've got a sales manager here who sends an email to their sales team at 8 p.m. on a Sunday night, reminding them to complete their monthly expense reports, which are actually due on Tuesday morning. The subject matter here is purely administrative. It's clearly not urgent, and it could have easily been scheduled to send during business hours on Monday. So in this case, the contact is likely to be considered unreasonable because obviously the communication is not critical, it's not urgent, and it needlessly intrudes on the employee's personal time. Just so I'm clear, the examples above that I just discussed, they're only there to illustrate what reasonable and unreasonable looks like for the purpose of working out whether an employee needs to respond to the contact. When an employer makes unreasonable contact with their employee, they're not necessarily breaching the right to disconnect law per se, but they need to be prepared for the possibility that the employee does not respond to such contact by law, right? Given the right. If the employer then decides to take action, like disciplinary action, because of the employee's refusal, that's when they could get into trouble. And by that, I specifically mean they could face a general protections claim or a Section 333N right to disconnect claim as well under the Fair Work Act. Next slide, please, Simon. For business owners and HR managers, what the right to disconnect law requires in practical terms is making sure that you have a clear policy or protocol on out of hours communication and that your staff, especially managerial staff, are properly trained on it. So, what does a good one look like? In my view, it should cover four key areas. So, with the first one, it needs to clearly establish what's considered working hours for different roles. So, for example, you could explicitly state that a standard full-time employee's hours are between 9 to 5, and that any contact made outside those hours fall within the scope of your right to disconnect policy. Second, it should set out a protocol for non-urgent contact. And this could potentially look like, mandating your managers and employees to schedule emails to deliver during the recipient's working hours. You could also potentially encourage the use of an email signature that states something along the lines of, I appreciate you may work different hours. There's no expectation for you to respond to this email outside of your working hours. Third, it needs to set out a protocol for urgent contact. Your policy should define what constitutes an emergency. So, with the example I gave earlier, it could be like a critical IT failure or a major security breach. And then it should also specify a single dedicated method for urgent contact, such as a phone call or perhaps a text message with a line beginning with the word urgent. Fourth, it should include a process for dispute resolution. So the policy should outline an internal process for an employee to raise a concern if they feel that they are being subjected to unreasonable out-of-hours contact from their employer. It should also make clear that adverse action like disciplinary action or a demotion or a dismissal will not be taken against an employee for reasonably exercising their right to disconnect. Now, let's turn our attention to some changes in the realm of privacy So in this part of our webinar, we're going to look at a change that aims to protect an individual's right to privacy. A recent amendment to the Privacy Act, which came into effect on the 10th of June 2025, so this year, introduced a new statutory tort of serious invasion of privacy. This law gives individuals a direct right to sue for damages in court if their privacy has been seriously invaded. Before this, suing for a privacy breach was actually really, really difficult, but this has clearly changed with the new tort. So, under this new tort, an invasion of privacy can be defined in two ways. There are two categories, essentially. So, the first category is intrusion upon seclusion. And this could be things like surreptitiously filming or watching an employee in a private space. The second type is misuse of private information. This law has quite a broad scope of application. And in the context of misuse of private information, it's not just confined to personal information or sensitive personal information as defined by the Act. So those two types are generally the sort of core concepts under privacy laws. It's not just confined to those two types. If an employer is found to have committed this tort, they could be ordered to pay damages, including non-economic damages as well. And what by that I mean damages for things like hurt, distress, humiliation, suffering, that type of stuff. This is critical for you as employers, as it clearly broadens your risk exposure just beyond the typical data breaches that you might have heard of in the media recently. So, if, for example, a manager inappropriately accesses an employee's confidential medical file or misuses private information gained through their work, the employee can now take legal action for a serious invasion of their privacy. It doesn't even require the employee to prove that they have suffered a financial loss, only that the invasion was serious and intentional or that it was reckless in nature. Next slide, please, Simon. It's a good idea, in light of this new law, to review your internal privacy policies, especially regarding employee monitoring and handling of sensitive staff data, and provide appropriate staff training as well. As part of that review, you would benefit from paying close attention to two specific areas that likely carry the highest amount of risk. The first one is intrusion risk. You may need to check your policies and practices concerning all forms of employee surveillance and monitoring. And this includes the use of perhaps CCTV or GPS tracking in company vehicles, keystroke monitoring software, and even what is typically visible to managers on shared drives or shared platforms. An intrusion upon seclusion can be committed by the mere act of watching or recording. The risk is highest when surveillance extends to employees in a state of seclusion where they have a high, reasonable expectation of privacy. The second is misuse risk. This may involve reviewing how you collect, use, and share employee information, such as health records, details of criminal conviction, for instance, or personal financial information. Risk likely arises when you use that information for a purpose other than the specific reason that you collected it for. So, for example, accessing an employee's health file to check their long-term sick leave status to perhaps manage an ongoing incapacity issue is one thing, and that might be completely warranted and legal. But using that information to unfairly decide on a promotion or demotion is potential misuse. So, to minimize the risk of committing this tort, your policy should be framed around transparency and consent. And in my view, there are three key aspects to this. The first one is there should be explicit consent for use. Your policy should explicitly state what information is being collected and, crucially, exactly how that information will be used. Where possible, you should obtain clear express consent from your employee for that use. The second one is there needs to be clear boundaries around monitoring. If you use surveillance like CCTV or computer monitoring or GPS, the policy has to be transparent about where, when, and how that monitoring takes place. The third and final one is there needs to be strong access controls as well. So your policy should mandate strict access controls with respect to employee information. So for example, only the payroll manager should be able to access pay-related information, and only HR personnel or health professionals should be able to access medical files. To wrap it all up, it's quite clear that this new tort is quite broad in terms of its application, and it goes without saying that it would heighten your exposure to risk for sure. And while that's the case, it doesn't mean that there's nothing you can't do about it. by taking at least some of the practical steps that we discussed earlier, it should go a really long way in minimizing the risk of committing this tort. Let's now look at a very recent legal development in the employment law space. Specifically, I'm talking about the Fair Work Amendment Baby Prius Act 2025, or what is commonly known as Baby Priya law. So with this amendment, it's an amendment to the Fair Work Act, and it's been designed to provide security during an employee's most difficult time. The law ensures that an employee's entitlement to employer-funded paid parental leave is protected if their child is stillborn or dies soon after birth. And this protection applies where a child is stillborn or dies on or after the 7th of November this year. So, what does the new law actually do? How does it actually work? The new law prevents an employer from refusing or unilaterally canceling an approved period of company-funded parental leave in the event of stillbirth or infant death. Any refusal or cancellation of such leave in breach of this law may result in your business facing significant civil penalties. Of course, as with any workplace law, there are always some exceptions. So with this protection, it does not apply if any of the following circumstances apply. So with the first one, this protection doesn't apply if the terms and conditions of employment before the 7th of November 2025 already have an explicit or an express mechanism that allows the employer to refuse or cancel company-funded parental leave in the event of stillbirth or infant death. By way of example, what I mean by this is this exception would only kick in if your paid parental leave policy says something along the lines of the employer may refuse or cancel your paid parental leave under this policy in the event of stillbirth or infant death. It has to be that clear, that explicit. The second one is it doesn't apply if under the terms and conditions of employment set before the 7th of November 2025, the employee is expressly not entitled to such leave because of stillbirth or infant death. So in simple terms, and again by way of example, the policy has to say something along the lines of you're not entitled to paid parental leave under this policy in the event of stillbirth or infant death. For the first two exceptions that I just discussed, I want to make a clear note that you as the employer cannot unilaterally vary the terms and conditions of employment after the 7th of November 2025 to give yourself the right to cancel or refuse company-funded parental leave in the event of stillbirth or infant death. Although unilateral variation is not allowed, there is nothing that stops an employer and an employee from reaching an agreement in the future to essentially allow the employer to refuse or cancel that leave because of stillbirth or infant death. The third and final exception is that the protection doesn't apply if your employee is entitled to some other form of leave related to stillbirth or infant death under the terms and conditions of their employment. And when I say other leave here, it does not include unpaid parental leave or compassionate leave. The key takeaway here is to check your internal paid parental leave policies if they are silent on what happens in the event of stillbirth or infant death. This new law provides the default protection. And if you are prohibited from canceling or refusing the leave itself, the protection will remain in place unless and until the employer and employee reach a mutual agreement to essentially dismantle that protection. Next slide, please, Simon. Okay, so we've spent a fair bit of time recapping laws that apply nationally. So now let's spend a bit of time talking about legal developments that apply to specific states and territories. So just the next one. Thank you, Simon. And continuing on with the topic of leave, 3 jurisdictions have either expanded their portable long service leave schemes or established such schemes for specific sectors. So if your business operates in the community services sector in either New South Wales or South Australia, you must be aware of the commencement of the new portable long service leave schemes in both states this year. If your business operates in the hair and beauty services industry or accommodation and food services industry in the ACT, on the other hand, then the territory's portable long service leave scheme has been expanded to cover you and your staff. So I'll start by discussing the new schemes in New South Wales and South Australia first. So with these 2 jurisdictions, the compliance requirements are a little bit different, of course. There are 2 states after all. With the New South Wales scheme for community service workers, it commenced on the 1st of July this year, and it is administered by an organization called the Long Service Leave Corporation. We've included the definition of community service on the screen here for your perusal. So employers of community service workers have two key obligations under this new law. Next slide, please. So with the first obligation, they have to apply for registration with the Long Service Leave Corporation. For employers who had already employed community service workers on or before the 1st of July of this year, they had to register by the 31st of July 2025, so this year as well. For those who are about to employ their first community service worker, they have to register within 1 month after that person commences working for them. Second, they have to lodge a return and pay a quarterly levy to the corporation, and this must be done at the same time. The levy is calculated at 1.7% of the gross ordinary wages of your community service workers. Because the scheme is so new to the sector in New South Wales, there's a grace period. So instead of needing to pay every quarter since the scheme commenced, the first levy payment covering 3 quarters is actually due from April 2026. At the time of this webinar, the corporation's website does not make it exactly clear when the return and payment are due. But if we are to go by the relevant legislation, it is likely to be the 14th of April 2026 or later that month. Moving forward, any future levy payment must be made on a quarterly basis. Next slide, please, Simon. Now let's talk about the South Australian scheme. It works in a very, very similar way. The South Australian scheme commenced just a few months after the New South Wales scheme's commencement, specifically on October 1st, 2025. And without going too deep into the technical details, the scheme applies to 2 categories of workers. So with the first one, it's for those who are covered by the SCHADS Award or the Aboriginal Legal Rights Movement Award, and they provide one of the prescribed types of services. So that's category number 1. Category number 2 is for those who spend at least half of their time performing roles that support the provision of such services. So these services are clearly community services. For convenience, I'm going to refer to these 2 types of workers as eligible workers. So if you are an employer of eligible workers, you have the following key obligations under this law. So next slide, please, Simon. Okay. So first, if you already had eligible workers as of the 1st of October 2025, you had 28 days to register with this SA Portable Long Service Leave. And second, you have to lodge a return and pay a quarterly levy. So not a surprise there. The levy is currently calculated at 2.2% of your eligible workers' total remuneration. And again, the lodgement of the return and the payment itself are due on the same date, and the due date is 21st of January 2026. Next slide, please, Simon. Okay. Now, let's quickly talk about the expansion of the existing scheme in the ACT. So as I mentioned before, the services industry scheme, which is part of the broader Portable Long Service Leave scheme, was expanded to cover employers and employees in the hair and beauty services industry, as well as the accommodation and food services industry as well. So employers in these industries need to register with ACT leave by the 30th of June 2026. And on top of this registration requirement, they must also lodge their first return and pay their first levy by the 31st of October 2026 as well. And the levy is currently calculated at 1.07% of your staff gross ordinary wages. Just the next slide, please, Simon. So moving on to my last bit of update before I hand it over to Simon. We're going to briefly talk about a new development to work health and safety laws in Victoria that came about as essentially a reflection of a growing focus on mental health as a safety issue. So in Victoria, the Occupational Health and Safety Psychological Health Regulations came into effect on December 1st, 2025. And with this regulation, it introduces the concepts of psychological hazards and putting in place controls to manage psychosocial hazards. So, what are psychosocial hazards? I've included the technical legal definition here on the slides for your perusal, but basically they are factors in the design, management, or systems of work that can cause psychological harm. So think high job demands, low control over work, poor support, things of that nature, essentially. Next slide, please, Simon. So, as employers, you now have explicit obligations to identify, assess, and control psychosocial hazards as far as is reasonably practicable. This means that you need to audit your workplace for these risks, consult your employees, as well as health and safety representatives where applicable, and put in place control measures to manage those risks. In terms of control, you need to eliminate psychosocial risks within your workplace as a first port of call. And measures to minimize these risks are only appropriate if you can show that it's not possible to eliminate them. There's a clear hierarchy here. Second, training and instruction can be part of your minimization controls, but they cannot be your predominant control measure. You need to look at changing the work design or systems to minimize your risk first. It's the final one, Simon, please. Thank you. In addition to these three aspects of your obligation, you need to also ensure that your controls work in the long run as well. The regulations explicitly require employers to review their control measures at specific trigger points. And as you can see on the screen here, there are 6 trigger points specifically, and I've included them over there. That's it from me, essentially, in relation to these updates. I hope you found it all informative. I will now hand it over to Simon, and he'll take you through some of the key case law developments this year, as well as potential changes on the horizon.
Thanks, Neath. So I'm going to talk about 3 big cases that occurred in 2025. In the slides, there'll be a link to the actual cases if you want to read them yourself or see the exact name of the case. But the first one concerns the SCHADS Award. We have lots of clients under the SCHADS Award, so we thought we'd talk about it today. The case was the Fair Work Ombudsman and Jats Joint, and this concerned the operation of sleepovers in the SCHADS Award. So the traditional understanding of how sleepovers work under the award is where a sleepover is worked, it's quite often for an employee to do a period of work before the sleepover and after the sleepover. So they might do some normal disability services work, caring for a participant for, say, 4 hours, and then the participant goes to bed, the worker performs a sleepover, and then in the morning they might do some more disability support work. And the traditional understanding was where work was organized like that whole period of work, so the period of work before the sleepover itself, and the period of work after it, would all be regarded as one long shift rather than 3 separate shifts. As long as they were kind of performed immediately before and after each other, it was regarded as one long shift. And the consequence of that, or the main consequence of that, was that the night shift penalty, the higher rate of pay that has to be paid for working a night shift, would apply to the whole shift. So it would apply to the period of work immediately before the sleepover and the period of work immediately after the sleepover, because it was regarded as all one shift. And the reason that occurred was because the definition of night shift means a shift that finishes after 12 midnight or commences before 6 a.m. Monday to Friday. And if you're working a sleepover, of course, your shift is going to finish after 12 midnight because you're there throughout the night. Now, the Jats Joint decision really turned that understanding on its head. And what the court found in that case was that a sleepover does not form part of a long shift together with the periods of work before or after it, and in fact it should be regarded as a separate shift. Now, the consequence of that would mean that the night shift penalty wouldn't apply to the periods of work before and after the sleepover, because looking at them as their own distinct shifts, they wouldn't satisfy the condition of a shift that finishes after midnight. So potentially this is good news for employers, because it means the night shift penalty is paid in fewer circumstances. Potentially there are other consequences of this decision. The usual rules under the SCHADS Award is that an employee can only work 8 or 10 ordinary hours in one shift. So it was usually thought that if you're working before and after a sleepover and it is regarded as one shift, you can work 4 hours before and 4 hours after, but no more than that. If it is the case that the sleepover is a distinct shift, then potentially employees might be able to work 8 or 10 ordinary hours, run into a sleepover, and then because it's regarded as a new shift, run immediately into a period of work and work 8 or 10 ordinary hours again. So that might be one of the consequences. It remains to be seen. The word of caution on all this is the case is being appealed. We don't know when that hearing is listed for yet or what the outcome will be, but it could all get turned on its head again. But what I've said so far is the law as it stands. There's also a couple of applications to the Fair Work Commission to vary the sleepover provisions generally. So we will have to see how those play out as well. We've got a detailed blog on this that you can read, and of course stay in touch with us and we will update you with the changes, any further changes, as soon as we hear it. Okay, the second thing I want to talk about, the second big case, was the Coles and Woolworths class action, which impacts employers who pay annual salaries to employees, particularly to award-covered employees. And what came out of that case was two important lessons about how the law works when paying annual salaries. And the first thing that case established is that where an employer is paying an annual salary, they need to make sure that the employee is paid sufficiently in each pay period. So that might be each week, each fortnight, each month, depending on how frequently you pay. An employee has to be paid sufficiently in each pay period. They can't just be paid sufficiently over the year as a whole. And average the payments throughout the year. In other words, it is not possible to underpay someone in one pay period, but overpay them in a load of other ones and say, well, over the year as a whole, your salary was sufficient. What you need to do is to make sure that each pay period, the portion of the salary that is paid is sufficient to cover all the entitlements that arose in that pay period. So predominantly we'd be talking about things like overtime, allowances, penalty rates, or for working at weekends or in evenings, that sort of thing. So there is one sort of caveat to that general position that I've described. Some awards do provide for an ability for employers to average the pay of employees over a year. It's not in many awards, but it is in a few, and that is called an annualized wage arrangement clause. These generally operate so that it is possible to average the pay over the year, to underpay in some pay periods and overpay in others, but they are subject to some very strict rules, which is why they're quite unpopular. They usually provide that the employer has to perform an annual reconciliation each year to assess the salary paid against the award entitlements, and if there is a shortfall, they have to make that good within 14 days. They also have to perform that reconciliation whenever the employment terminates, and there is also usually a very strict record-keeping obligation, which requires employers to keep a timesheet of the hours that the employee works, and for the employee to sign off that they agree to that record each week or each roster period. But if your award doesn't have that sort of provision, then the general approach that I've said about making sure employees are paid sufficiently in each pay period applies. The second lesson that came out of the case is that when an employee is paid a salary which is designed to meet all entitlements, even if it is clear that that salary is sufficient to meet all the entitlements that arise in each pay period. The employer still needs to keep a record of the entitlements that arose. So for example, say you've got an award-covered employee, they only ever work a maximum of 3 hours overtime a week. You know that's the case, and they're paid weekly, but you've set their salary so that it covers up to 5 hours overtime per week. It is clear that their salary is going to be sufficient to cover all the entitlements in each pay period. Even in a situation like that, the employer is still required to keep a record of the entitlements that arose in that pay period that the salary has met. In other words, a record of the overtime hours the employees worked, any allowances they're entitled to, any penalty rates that would have arisen. So those are two pretty big and significant clarifications of the law. The key takeaways are obviously, if you are paying award or enterprise agreement staff a salary which is designed to cover everything, make sure you are paying them sufficiently to pay them a rate in each pay period that covers all the entitlements, not just over the year as a whole, and make sure you're keeping adequate records of all the entitlements that arise under the award. If you do need any assistance in understanding how that affects your business, it is a reasonably sort of complex idea, I suppose. Do reach out and we can talk you through it. The third case I wanted to discuss was the case of Chandler and Westpac, which involved a flexible working request. Now, the background to this was Mrs. Chandler had been working remotely and only coming in to the office on an occasional basis. Westpac then introduced a policy which basically said all employees have to work in the office at least 2 days a week for reasons of face-to-face collaboration and the benefits we think that brings. Mrs. Chandler didn't want to do that, so she put in a flexible working request which asked if she could work every day from home. And the reason that she wanted to do that was so that she could do school drop-offs and school pickups on each day. The reason that she was making the request, it wasn't to change her working hours. It was just that the Westpac offices were quite far from her home and the childcare or the school was quite close. So if she had to travel to the Westpac office, she wouldn't be able to get she wouldn't be able to do the drop-off and pick-up and still be at work on time. Whereas if she was working from home, she could do the drop-off and pick-up and still start work at the hours she was required to. So she put in the flexible working request and Westpac refused it. Mrs. Chandler then made an application to the Fair Work Commission, who found that Westpac's refusal of the request was unlawful, and they ordered Westpac to allow her to work from home on a permanent basis. And this case is important because a lot of the decisions sort of go the other way, but this is one of the first where the Fair Work Commission has made a determination that the employer couldn't lawfully refuse the flexible working request. So why did they make that decision? Well, it is very clear that the reason that they made that decision was because Westpac didn't follow a number of the steps which are required when dealing with a flexible working request as set out in the Fair Work Act. So the Fair Work Act has a very prescriptive series of actions that have to be taken when a flexible working request is received, and Westpac didn't follow all of them. So in particular, they did not reply within the 21-day time limit of receiving the request that is required. They did not engage in meaningful discussions with the employee aimed at reaching an agreement on the flexible working request, which is also a requirement of the Act. Very importantly, they did not provide specific reasons which were specific to Miss Chandler's case as to what the reasonable business grounds for refusal were. Rather, they just referred to this general policy that we believe that employees need to be in the office for the benefits of face-to-face collaboration. But they just relied on this kind of general view without applying it to the employee's circumstances. And her circumstances were that she worked in a team where some of her colleagues were in Brisbane, some in Melbourne, some in Sydney. They're all in different offices. So this general argument that face-to-face collaboration was required didn't seem to marry up with her situation because her colleagues were in different offices, so they weren't going to be meeting face-to-face anyway. And Westpac didn't explain, how this policy of collaboration applied to her specifically. And lastly, it couldn't show that it had considered the impact of the refusal on Miss Chandler's individual circumstances. And she was arguing that if it wasn't granted, she would have to consider leaving her job. Westpac couldn't show that they had considered the impact of that on her and balanced it against the needs of the business, which is a requirement of the Act. So I think that the take home or the takeaway point from this is it is not clear had Westpac, ticked all the boxes it should have done, whether the Fair Work Commission would have came to the same view. We'll never know, but it is absolutely clear from the decision that the reason that they went down the route that they did is that Westpac hadn't followed all the requirements of the Fair Work Act, and in particular, if you are dealing with a flexible working request, you really need to show, if you're refusing it, why the particular policy you have applies to the individual and their individual circumstances. Just having a kind of vague argument about we believe in collaboration, face-to-face collaboration for everyone, but not saying why that it's particularly important for a particular role is going to leave you at risk. So that's the main point I wanted to bring out with that one. Okay. Those were the cases I wanted to talk about. Let's look at 2026 and a few important things that are on their way. The first thing is Payday Super, which is being introduced from the 1st of July 2026, as hopefully you are aware. This means that superannuation will have to be paid at the same time wages are paid, whether you're paying weekly, fortnightly, monthly. Every time you pay an employee, you'll also have to make a superannuation payment, which will have to be received into their super fund within 7 business days. That is obviously a big change from the obligations employers have at the moment, which is to pay super quarterly. And this is obviously going to cause a lot of challenges, both for business cash flow and the extra admin and payroll processes that are going to have to be in place to deal with super payments, pay period to pay period. Employment Hero, as you'd imagine, has a wealth of resources to help with this, and it has some great new functionality, which we're calling Hero Clear, which will take out all of the admin out of paying super and will therefore reduce the risk of errors and the possibilities of employers being penalised. So do check out the functionality we're developing there, because it is a real game changer. The second thing that is happening on the 1st of July are some changes to parental leave. The first thing that is happening is the number of days that can be taken as flexible parental leave will be increased from 120 days to 130 days for any child born or adopted from 1st of July 2026. Hopefully you're across how flexible parental leave works. It's been around for a couple of years now, but in a nutshell, it is an employee's right rather than to take parental leave all in one big chunk of 6 months, 9 months, 12 months, whatever. Employees are allowed to keep in their back pocket, as it were, a bank of days to be taken flexibly. So, for example, they might take a big chunk of parental leave, come back to work, and then reserve themselves the right to take a number of days on random occasions. The amount of days that they can take, as I said, is going up to 130 days. Government-funded parental leave pay, so that means tested benefit that certain employees who are on the lower kind of earnings scale of things are entitled to. That is increasing to 130 days leave from the 1st of July 2026. And hopefully, as you know, that can be shared between both parents. We no longer have the separate dad and partner pay. It is all lumped together, and that will be an 130-day entitlement from the 1st of July 2026. So make sure that your policies are updated to reflect those changes. Of course, if you're using Employment Heroes template policies, we will be making sure that they are all up to date to reflect those amendments. Okay, and then what's next? Okay, this is something else which we're going to see in 2026. I'm sure, though we're not quite sure of the date. So in April 2025, the Fair Work Commission made a provisional decision to increase some of the pay rates in the SCHADS Award because they found there was no longer any justification for home care employees being paid at a lower rate than social and community services or crisis accommodation employees. They also found that the existing classification structure, where there are different classification schedules for home care and SACS employees, etc., was way too confusing. So there should just be one simple classification structure for everyone, based largely on years of experience and qualifications. They put together a proposed classification structure, but there were some hearings in April 2025 where, in particular, the ASU union raised some issues about that. So that is being looked at again. We don't know the date for the next hearing, but it is very likely that at some point in 2026, we're going to have a new classification structure in the SCHADS Award and new pay rates for a lot of employees. So watch this space. A couple more things before we move on to the next section. This is hot off the press. This is a new law in Victoria, which was passed last week, which bans NDAs that concern sexual harassment. So we don't know the date that this will come into effect, but it will be the 1st of November 2026 or before that. And how this will work is it will ban new non-disclosure agreements from being used to stop workers discussing sexual harassment that occurred in the workplace. That will cover standalone NDAs. It will cover deeds of release or deeds of settlement. It will cover employment contracts. It covers the fields. Victorian employers will only be able to require or suggest an NDA in sexual harassment settlements if the complainant specifically requests one. Employers will also be required to provide the complainant with a detailed information statement and allow a 21-day review period before the complainant signs it, and they must avoid exerting any undue pressure on the complainant to sign the agreement. And importantly, complainants will be able to terminate an NDA after 12 months in any event. So if you are an employer based in Victoria, it is going to be important, I think, to review any kind of templates that you have that might deal with sexual harassment, and to consider your obligations very carefully if you are dealing with any sort of complaint or settlement in this area. Another change which is likely to be on its way, although it hasn't been legislated yet, concerns the ban on non-compete clauses in employment contracts. And this is at a federal or national level. The government announced in the 25-26 budget that it wanted to ban non-compete clauses in employment contracts for employees earning less than the high income threshold, which is currently $183,100 per annum. The argument is that non-compete clauses stifles innovation and productivity, and also keeps wage growth down, because employees tend to move to new jobs and get higher levels of pay. The government said that these changes will come into effect in 2027, but we don't have any legislation to carry through these amendments yet, and so that legislation will obviously still have to be debated and passed. It's also, not entirely clear how much of a practical impact this will have. Non-compete clauses are notoriously difficult to enforce already, particularly for kind of less senior employees. And nothing in the new law will change an employer's ability to have a non-solicitation clause, so a clause which prevents an employee from contacting clients of a business, for example, or a non-poaching clause which will prevent a former employee from stealing staff. So some protections will remain. All right. So before we've got a couple of minutes left, so before we move to a Q&A to look at a few of your questions, I just wanted to briefly recap. From what we've seen today, it is clear that employment law is moving at a very fast pace, and that pace of change means employers need strong systems and reliable processes in place well before next year. If you're not currently an Employment Hero customer, we are offering a short employment evaluation, which is basically a quick conversation with one of our experts to look at your HR and payroll setup and help you understand whether our platform and services could strengthen your compliance and processes ahead of 2026. If you do decide to move forward with any of those, we're currently running our Hero Head Start offer, which means if you sign up before 19th of December, your first 3 months will be free. If you're already an Employment Hero HR software customer, but you don't currently have our HR advisory service or Employment Hero payroll, this conversation would be a chance to explore whether access to our payroll services or to our HR advisors as an additional add-on could help your team manage more complex issues and reduce the risk of costly mistakes. These calls are designed to help you assess whether these solutions are the right fit for your organization. So there is a QR code on the screen, and a link will also appear in the chat box. If you'd like us to contact you, please click on the link or scan the QR code on the screen and fill in your details, and an employment specialist will reach out to you. Okay, so let's just have a couple of questions. We've got a couple of minutes left, so we won't be able to take too many. But Neath, did you pick out any good ones?
Yeah, there are definitely a lot of really good questions there, Simon. So the first question that you might be able to answer, Simon, is in relation to the Coles and Woolies decision, are there any implications for non-award employees?
I think if you're paying a non-award employee an annual salary, the case still applies. That the general idea is that, an employee has to be paid sufficiently in each pay period, and that applies to award and non-award employees. But if you're paying a non-award employee a salary, they're not going to be entitled to overtime or penalty rates or anything like that under an award. They're just going to be entitled to the minimum wage for each hour they work. So, um, practically speaking, I don't think you're going to have an issue in most circumstances with their entitlements going up and down, like you would with someone entitled to overtime under the award. So I think it's going to have a lot less of an application to them on that level. The second thing which I talked about was this record keeping obligation, which was an obligation to keep a record of any sort of extra entitlements that someone was entitled to under an award, overtime, penalty rates, etc. So again, that's not going to apply to an award-free employee. So the record keeping side of it is not going to have any real application either. So yeah, no, I don't think it's anything to really worry about if you, in respect of your award-free employees. But obviously, anyone covered by an award or an enterprise agreement, that is where you really need to think about whether there's anything that you need to change up or review.
Awesome. Thank you so much for that, Simon. I think that's all we have time for in terms of questions. So just to wrap up, thank you so much everyone for joining us today for our last webinar of 2025. A survey will automatically launch after we end the webinar, and we would really appreciate it if you could take just a minute to please fill it in. We'll also be sending out some additional resources along with the webinar recording after today's session. Have a wonderful afternoon and a fun and safe holiday period. We'll see you all next year.
Thanks, everyone. Goodbye.
Thank you. Bye.